Good morning, Counsel.
Good morning. My name is Kirsty Pecci, and I am the pro bono counsel for the appellant, the 2810 citizen groups. My clients are asking the court to hold that the acreage and use were not expanded, in the site assignment, were not expanded by the 2008 minor modification to site assignment. Secondly, to vacate any holding by the Superior Court or Board of Health assuming that the use of processing has been site assigned or that more than 52.8 acres were site assigned. And thirdly, to find that the 1979 site assignment and the 1999 modification to site assignment only site assigned 52.8 acres for the sole use of landfilling.
Are you going to address the sort of standing and lateness of the appeal issues as well?
Certainly. Would you like me to begin with the standing? Or
Sure.
Okay. I think you'll find in further review that standing is very clear in this case. Mass General Law, Chapter 30A, Section 10A, confers standing for all appeals under Chapter 30A by 10 citizen groups, so long as they are appealing adjudicatory proceedings in which damage to the environment is at issue. This is an appeal under Chapter 30A, Section 14 of an adjudicatory proceeding. Chapter 111, Section 150 states that for purposes of appeal, site assignments are adjudicatory proceedings, where the potential for damage to public health, safety, or the environment was at issue. For further elaboration on this point, please see the amicus brief submitted by the Conservation Law Foundation and the Charles River Watershed Association.
Well, Section 14 says that persons aggrieved by a final decision. Isn't that the whole point, whether a 10 citizens group is aggrieved by a final decision?
Yes, but you'll see if you look to Section 10A, that
Section 10A of
10A
what?
of Chapter 30. So a few
Of 30A.
of 30A, yes, excuse me. So Section 10A of Chapter 30A states specifically that for purposes of appeal, any 10 citizen group may bring an appeal in an adjudicatory proceeding, which this clearly is, when the issue is damage to the environment.
Could you pause on whether this is an adjudicatory proceeding? Because the code itself at 1620 says it is not. So how do you reconcile that?
Chapter 111, Section 150A states that for purposes of appeal, it is an adjudicatory proceeding.
But actually,
It doesn't.
10A says, any such intervener, which would include you, shall be considered a party to the original proceeding for the purpose of notice and any other procedural rights applicable, including specifically the right of appeal. So you are a party
Yes.
for purposes of appeal, but I believe that your brother in a moment is going to say that the statute recognizes that you may be a party but not necessarily be aggrieved and therefore entitled to appeal, that your rights as a party may be limited to intervene with regard to a suit brought by somebody who was aggrieved, but not to initiate a suit yourself.
Well, if you look closely at 10A and also taken in conjunction with Chapter 214, 7A, which grants 10 citizen groups the right to defend the environment. And that is out of the Article 97 of the Constitution of the Commonwealth, which provides all citizens with the right to clean air and water and protects their rights. You'll find that my clients are aggrieved by the very fact that they are 10 citizen groups in an adjudicatory proceeding who are protecting protecting the environment. I think that also it is important that the court look to the DEP cases on this issue, especially the 1988 case in the matter of Riverside Steam and Electric Company and their progeny. And that line of cases has not been cited in any of the briefs before you. But there, it makes very clear, when you have an adjudicatory proceeding, for purposes of appeal, if you are to protect the rights of not only the applicant, but all the parties to the adjudicatory proceeding, which my clients were full parties to the proceeding, it is necessary to allow appeal not only when the applicant is denied their application, but also when the 10 citizen groups or other interveners appeal a positive determination for the applicant in which the damage to the environment is actually, there's more possibility of damage to the environment because the application has been approved. And I think that that's clear. But I also would argue that the court should afford judicial deference to the administrative hearing officer who found that my clients were aggrieved. My almost 300 clients filed affidavits with the hearing officer before the beginning of the hearing, which detailed their aggrievement. The affidavits were signed under the pains and penalties of perjury, and she evaluated those affidavits. My brother-in-law had the opportunity to challenge those affidavits. In fact, on the case of one intervener, he did challenge their right to intervene. And she found that those 10 citizen groups could intervene and become full parties to the proceeding.
Could she, I'm sorry, I'm trying to understand Section 10A. Would she, I understand those are the rules of the hearing. Would 10A allow her to say, you, that 10 citizen group, you're not aggrieved, I'm not going to allow you in? She could do that consistently with 10A?
No, 10A does state that if any 10 citizen groups, so they don't have to live near the facility or or abut the facility, any 10 citizen group, because they are a 10 citizen group, and if the issue before the body is damage to the environment, which Chapter 111, Section 150A states that the standard before the Board of Health was, is this a potential harm to public health, safety, and the environment? So the standard was in place. I would argue that all 10 citizen groups must be allowed to be parties.
So I guess what I'm saying is, then we don't need to look at what the hearing officer did, because what you're saying is under 10A, she had to do what she did. Whether she found them to be individually, she made some individualized determination that this group was aggrieved or not. You're saying 10A would say every 10 citizen group, if the issue is damage to the environment, they're all in.
Absolutely. 10A states that all 10 citizen groups are in for the underlying proceeding as well as the appeal. But I would also argue that 310 CMR 16, which governs her behavior, works with 10A and does not controvert 10A, because all 10 citizen groups have the right to protect the environment under Chapter 214(7)A, and also because Article 97 of the Constitution exists, where all citizens have the right to protect their right to clean air and clean water. So instead of saying, well, the 310 CMR 16 provides this despite 10A, I would argue instead that 10A as well as 310 CMR 16 are put in place because they all work together. They do not contradict each other. My point regarding the deference we should provide her is that she did receive statements of aggrievement from my clients. I don't think it's necessary to look at that. I think that 10A gets you there. However, that aggrievement has already been detailed and was submitted prior to the hearings beginning, and my brother-in-law attached them to his brief. They were signed under the pains and penalties of perjury. At no other time were my clients asked, have you been aggrieved? We're talking about almost 300 people who live very close, within a mile or two, to this landfill. And this will be the largest MSW landfill, municipal solid waste landfill, in the Commonwealth of Massachusetts. We're talking about 500,000 tons of municipal solid waste and construction and demolition materials that will pass. Certain of my clients, all of that 500,000 tons will pass their homes on their way to this facility. The odor...
You leave that issue, though, and there was another question, and if you would address it, please. Why are you here if the appeal is not timely?
Your Honor, I made an error, which the Superior Court found it was an excusable error, and filed the notice of appeal a day late. The Superior Court did...
Where was the finding of excusable?
The Superior Court found that it was an excusable error.
Finding?
On January 19th, the Superior Court clerk accepted my notice of appeal for filing and filed that document. I had 30 days to cure and to request that the court allow me an extension to file that notice. However, I did not realize that I needed to do so because the clerk had already accepted it for filing.
But isn't the argument that because I think it was March that this all was occurring? Was that when the hearing was?
Mm-hmm.
Is that right?
Yes.
That's more than 30 days beyond the 30 days. So it's more than 30 days beyond February 15th, I think, or whatever the day was.
Right, it was,
So she didn't have, that is, Judge Kenton Walker didn't have power to do what she did.
well, the confusion arises because, as I said, I submitted this to the clerk, and the clerk actually accepted and filed that notice of appeal on the 19th, the day after it was due.
And docketed
So-
it? Was it docketed?
Yes, it was docketed on the 19th, and that's in the record, it's stamped by the clerk on the 19th. So as a result, I was not aware that I needed to request a motion to excuse my error, because
Because you
I-
knew, but you didn't know that it was a day late?
no, I mean, my brother-in-law did make a motion to dismiss, but it certainly wasn't the first motion to dismiss I'd gotten from him, and the clerk told me that I was correct in filing it. So that was my error, and the Superior Court found it was an excusable error.
But I think we've generally said that's not something you can rely on. If the law requires 30 days and you didn't do it in 30 days, then you would have had that knowledge, whether you actually did or
Right.
didn't, presumed to have had the knowledge that you weren't timely and taken whatever steps you needed to take.
I agree. I thought that because it had been docketed, that it had been corrected in that way, that it was understood. And that is what the Superior Court judge found.
If I could turn you back to the issue of standing, is it your view that there's no need for 10 persons to be aggrieved, or that by the nature of 10A, in terms of what kinds of cases they're allowed to intervene in, that you've established that they are aggrieved because you live in this environment and you've been damaged?
The second, Your Honor. If you are trying to protect your right to clean air and water, this is a very limited situation which agreement is not necessary. This is not a zoning case or an insurance case, as you'll find many of the cases cited by the appellees are. This is a damage to the environment case by a 10-citizen group to an adjudicatory proceeding. And case law also finds that they must be parties to the underlying adjudicatory proceeding. So it's a very narrow set of circumstances to which this applies. And I think that the law states that 10 citizen groups in this situation automatically have standing to appeal that adjudicatory proceeding.
Are they the equivalent of it's a private attorney general action, essentially, is what you're saying?
Correct. I think that you'll find in this case, as in many others, the right to clean air and water has not been protected adequately. Here, you will find that there have been assumptions made and missteps made by the government for whatever reason. For instance, the processing facility on this site has never been site assigned. The issue of whether a processing facility could damage public health, safety, and the environment has never been evaluated by the Board of Health. Yet this has gone forward. Further,
So you're actually asking us to view your clients not as aggrieved private individuals, but people who are authorized by statute to act in the public interest.
Your Honor, I would state that my clients are aggrieved private individuals. They may be doing the work that the state government should be doing, but all of us, when you're talking about a facility that's going to take in 500,000 tons of solid waste a year, this is going to impact the resources of the community.
I'm only asking about the nature of this group. Are they private individuals who are actually aggrieved, or are they private individuals who are acting in a different capacity and who are authorized to defend or protect the public interest?
Both. They are actually aggrieved, but here, through their pro bono attorney, they are taking steps to protect the damage to, against damage to the environment for the entirety of the Commonwealth. And it's appropriate, especially here, where you're dealing with a large-scale facility. We're not talking about blocking a view here. We're not talking about how close a porch is to a sideline. We're talking about a project that's going to impact clean air, clean water, a huge traffic impact for miles around, and impact the resources of the Commonwealth and whether they're recycled or buried. So I would argue that my clients are taking this step and being both. I would refer the court also to 310 CMR 16.057D7, which which speak specifically to processing facilities and their
Let me just
requires.
let me just get back to that question for a minute. If the hearing officer at the administrative level did not recognize your client as interveners, do you have any right to appeal that to a judicial body? Or is that an act of, is that committed to the hearing officer's discretion?
It is committed to the hearing officer's discretion. There's deference afforded to her.
Okay.
I see that my time is up. Thank you very much for allowing me to present my case to you.
Thank you. If it please the court, I'm Robert Kirsch on behalf of the Southbridge Recycling Development Park, and with me is Sarah Torano Flores for the Board of Health. I'd like to start by responding further to the court's questions on Section 10A. As was pointed out by the amicus CLF, that section was not briefed by the parties. It was not briefed by the parties because the plaintiffs here had conceded that it was not applicable during the course of the proceedings below.
And you say it wasn't briefed where? You mean on appeal?
It wasn't briefed on appeal to this court. It wasn't the theory of Section 10A was first raised in the amicus brief of Conservation Law Foundation.
It's certainly in none of the briefs we have other than the amicus brief.
Correct. And the reason is that it was conceded by the plaintiffs that it was not applicable below. And I'd like to point out that 10A has no place here, that plaintiff's concession below was appropriate, and we will be submitting.
Where was that
it?
concession?
The concession was in a motion for judgment on the pleadings, Your Honor.
Why is it appropriate
Why was what? I'm sorry.
to concede it? I'm just...
It's appropriate to concede because 10A does not apply to appeals of Board of Health site assignment decisions. That is controlled by 38 Section 14 and Chapter 111, Section 155. 10A does apply to adjudicatory proceedings and permits 10 citizens groups to participate in those proceedings. We will submit under Appellate Rule 16 the legislative history to Chapter 10A, to Section 10A, which will show that in every iteration of that statute, beginning in the August 1970 House bill, running through the March 1971 House bill, there was in fact language that would have satisfied would have rendered accurate the arguments that CLF and the plaintiffs have just made, that 10A would be sufficient to get them in as parties, but that in the ultimate bill, and if we read Section 10A, we can see that the final sentence to that section does not contain language suggesting that it is there notwithstanding other provisions either of the section or of Section 10, the earlier provisions of the statute in 1970 and 1971, in fact, had the notwithstanding language. And we would submit that it's very clear that what the legislature intended was that parties be, that 10 citizens groups be accorded status as parties, but not have the right to appeal absent a showing of aggrievement.
And how do 10 persons show aggrievement when their right to intervene in the adjudicatory proceeding is limited to damage to the environment?
I think it's very difficult for 10 citizens parties to make that showing, Your Honor. These parties did not come in to the case under 10A. They came in under 310 CMR 16.20 sub 9.
So if they did come in, and is that the one that is that why the hearing officer found them to be aggrieved?
She did not make a finding of aggrievement, Your Honor. The finding that's made under 16.9 is something less. It is that they are substantially and specifically affected, and by signing the forms that they signed, they are deemed substantially and specifically affected, and that gives them the right to participate as a party.
So how could they ever present a record, a factual record for us to review in a 30A proceeding if the issue essentially is not even litigated at the administrative level as to their aggrievement, is not even I take it it's not an issue. It's not a factual issue below.
At the stage of the hearing, that's correct.
So how can they possibly create a record suitable for appellate review on this issue?
The issue is treated as, the standing issue is a jurisdictional one, treated as a 12B1 issue, and the court is entitled to look to documents outside of the pleadings to establish standing. And it was
So can they establish a factual record, perhaps de novo, in front of a Superior Court judge under 30A? Is that what they have to do? 300 people get up in front of a Superior Court judge and show how they've specifically been aggrieved?
well, certainly only one would have needed to show aggrievement, Your Honor,
Not 10.
not 10.
It's a 10-citizen group, though.
Well, had the parties chosen to show that the group was aggrieved, then arguably they would have had to show that each member of the group was aggrieved. I mean, we have a unique situation here where typically, as this court has pointed out in various times, unincorporated associations aren't subject to suit. There are some exceptions for labor unions, for condominium associations. There is no exception here for 10 citizens groups in the context of an appeal of a site assignment decision.
Let me ask you this question. You say in your brief, well, Robinson versus the DPU, if I have the name right, it's one of the Stanley Robinson cases, isn't applicable because it's 25-5. But, you know, in that case, the court said, well, the DPU afforded Mr. Robinson full party status, therefore he gets to appeal. And when he was limited party status, he didn't. Why shouldn't we apply this? I don't understand why 25-5 doesn't offer an analogous situation.
The standard in 25-5 is an aggrieved party in interest, so there are two prongs to the test. Some of the cases that are mentioned in the briefs focus principally on the party prong and don't really get to the aggrievement prong. But that statute, 25-5, requires both party status and aggrievement. In this instance,
Well, so Mr. Robinson, at least as I read this court's decision, when Mr. Robinson was accorded full party status at the DPU, this court said, yes, you may appeal to us.
yes, well, party status is a necessary prong. I don't believe that the issue of aggrievement was necessarily ruled on in the decision Your Honor is talking about, although I'm not sure precisely which case you're referring to. There are several of the decisions, Save the Bay, for example, which has a discussion that would suggest that the aggrievement standard is lower, that the threshold somehow dropping, but it's really not. The discussion is simply focusing on the party prong of the party in interest and aggrievement standard.
But where Chapter 30A is essentially based on the administrative record and where the hearing officer grants party status, why shouldn't that be the end of the inquiry?
Well, the hearing officer has granted party status to the administrative hearing, and keep in mind, Your Honor, the hearing before the Board of Health is a legislative hearing. Up until the time that a decision is rendered and we go to appeal, and it is deemed to be an adjudicatory proceedings for purposes of the appeal, it's legislative. That means that the standard is permissive. The concept is to get as many parties in as possible. The idea behind the regulatory provision at 1620 sub 9 is to permit 10 citizens groups to bring in issues so that nothing will be left unaddressed. There won't be any points that aren't put before the board.
If it's essentially a legislative hearing at the administrative level, doesn't that give your client, put your client in exactly the same position as her client? People, there's simply two different entities making a petition to a legislative body.
At that point, that's correct. And then when the decision is rendered, and if it's appealed, it is an adjudicatory proceeding, and it is treated that way under 30A.
So if for purposes of the administrative hearing, you are both essentially parties, and you're not really, your rights have not been adjudicated at the administrative level. They may be at the 30A proceeding. So why doesn't the whole thing get teed up to the Superior Court judge where the parties had exactly the same status that they had at the administrative level?
Well, because Chapter 111, Section 150A is very clear, Your Honor. It says that any person aggrieved by the Board of Health decision may appeal. It is not a concern of the court in that context whether someone was a party or not. You need not be a party to appeal a Board of Health decision. You need simply be a person who can demonstrate aggrievement. It's a very different standard than some of the statutes that require participation.
Let me ask it a different way. If the administrative hearing is essentially legislative in nature, and you lost and appealed under 30A, why don't you have to show you've been aggrieved?
We would. But if we lost on an application for relief that a party was requesting, it's very likely that the aggrievement standard could be met in a relatively straightforward way. I think part of the issue here is it is a 10 citizens group, and the nature of the proceeding before this Board of Health was very limited. If you
Just also about that particular point, isn't there a distinction between how they were admitted, whether as interveners or full party participants? Is that the stage at which that's decided?
They were, with respect to the hearing below, they were full party participants, but that did not vest them with any rights on appeal.
Full party participants for the purpose of that administrative hearing.
Correct.
And then the next stage, you're saying we look to the statute to make or the nature of the proceeding also, and the statutory language to decide whether they fit within either presumptively aggrieved status or they must show it.
Correct, Your Honor. In this instance where the statutes are clear, we have specific jurisdiction, we have specific standing issues stated in 150A and 30A Section 14. This court's earlier decisions on standing dictate that we don't look to the Administrative Procedure Act when there is a controlling statute, and here Section 150A does control and directs that a party to have standing must be aggrieved.
But help me to understand what it means to be aggrieved for a 10-person group. I worry here that you may be losing by winning, and that this proceeding is now going to be extraordinarily burdensome as a court has to first ascertain how many of the 10 must be aggrieved, what it means to be aggrieved. I mean, that deflects the court from reaching the merits, will prolong the 30A proceeding. Is that ultimately going to be helpful?
It is the burden of the plaintiffs to make some demonstration of aggrievement. There was no...
What do you say is sufficient?
Well, the cases suggest an injury that is different from an injury suffered by the public, and one that is within the purview of the statute, the interest protected by the statute. And here, there's been no allegation of that. There is one unsupported allegation in the complaint that the parties are aggrieved, and nothing more is said. And under the standards applicable in the standing decision, that's simply not sufficient.
You mean it's not enough that they can show that trucks filled with tons and tons of demolition waste will be driving by their homes, hundreds of trucks a day perhaps? That's not enough, giving off dust.
Well, if a person could show injury different from other persons, Your Honor, that would show aggrievement and would entitle them to participate. Here, that hasn't been alleged. There's nothing in the record that would support that kind of a finding. I'd like to just quickly address a couple of issues with respect to the jurisdiction question. We would largely stand on the briefs, except to point out that there was no finding of excusable neglect by the trial court here. The filing was late. By the time the trial judge acted, the 30 days had expired, and she was without authority. And there was no request. There was no demonstration of excusable neglect.
Just be clear. Was it docketed one day late?
I believe it was
That's
docketed.
what your sister says. One day?
We would accept that, Your Honor. It was docketed one day late, and we immediately filed suggesting that it was late and that we were going to act against the plaintiffs because of that. And so that she was on notice that she was late immediately.
And did the judge make any findings regarding this one day late docketing?
I don't recall any findings regarding the 1 day late, Your Honor. The judge invited the plaintiffs to move to extend the time in which to make the filing. The plaintiffs did that. We pointed out in our motion for reconsideration that it was too late and that the court lacked authority at the time to take that step. And I believe that the law under Rule 4 is quite clear on this.
Does it make a difference that the filing, in fact, occurred within that 30-day period?
It does not.
Was the extension period? I mean, is there any case that says that a filing within that 30-day period following the docketing, or following the day it was due, the 30 days within which the appeal should have been filed? This is not, I mean, it's not a matter that the judge tried to extend it into March. The judge extended it for a 30-day period of time, presumably, and it was, in fact, docketed in that 30-day period. It had already been docketed in that 30-day period of time. I'm not aware of any case that deals with that set of circumstances.
We found none either, Your Honor.
All right.
Thank you, counsel.